Hi, Christopher here, and welcome back to the Patriot Report, where we bring the Constitution to life, one amendment at a time. Today, we're taking a deep dive into the Fourth Amendment, an essential part of your personal freedom, your privacy, and your protection from government overreach. Let's start with the actual text. It says, "The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized." That was a mouthful, right? But let's break it down. The big idea: your right to privacy. The Fourth Amendment protects one of your most fundamental rights, the right to be left alone. It says the government can't go poking through your home, your phone, your car, or even your pockets, without a good reason. That reason must be backed by probable cause and, usually, a warrant signed by a judge. Why is this so important? Because the Founding Fathers lived under British rule, where writs of assistance allowed officials to barge into homes and businesses, searching for smuggled goods without much explanation. It was invasive and abusive, and the Founders wanted to make sure that didn't happen in the new American Republic. What counts as a search or seizure? Great question. A search happens when the government invades a space where you have a reasonable expectation of privacy. That might be your home, your phone, your backpack, or even the data on other devices you own. A seizure means the government takes something, maybe your property, or even you, if you're being arrested. Here's the key: not all searches or seizures are unconstitutional. The Fourth Amendment only protects you from unreasonable ones. What makes a search reasonable? In most cases, the government needs a search warrant. To get one, law enforcement has to go to a judge and show probable cause, a solid reason to believe that a crime has been committed and that evidence of the crime is in the place they want to search. The warrant also has to be specific. The police can't get a blank check to search your entire life, they need to describe exactly what they're looking for and where they're going to look. For example, if they have a warrant to search your garage for stolen bikes, they can't use that to rummage through your sock drawer. That would be outside the scope of the warrant. Are there exceptions? Yes, and they matter. There are several important exceptions to the warrant requirement. Let's go over a few common ones. Consent. If you say sure, go ahead and look, then a search is legal, even without a warrant. So be careful what you agree to. Plain view. If the police are lawfully in a place and they see something illegal, say, drugs on a table, they can seize it without a warrant. Search incident to arrest. If you're lawfully arrested, police can search you and the immediate area around you for weapons or evidence. Exigent circumstances. If there's an emergency, like someone screaming for help or a suspect about to destroy evidence, police can act fast without a warrant. Automobiles. Because cars are mobile and heavily regulated, police have more leeway to search them, especially if they have probable cause. What happens if the government violates the Fourth Amendment? Enter the exclusionary rule. This rule says that if the government gets evidence through an illegal search or seizure, they can't use it against you in court. That evidence is considered tainted and gets thrown out. It's kind of like if a referee sees a foul before a goal is scored. No matter how great the play was, the goal doesn't count if the rules were broken to get there. This helps keep law enforcement accountable and reinforces the importance of respecting your constitutional rights. Modern challenges, technology and the Fourth Amendment. When the Fourth Amendment was written in 1791, there were no phones, no internet, and no GPS. Today, courts are constantly figuring out how this old amendment applies to new tech. Can police track your location through your cell phone without a warrant? Can they search the contents of your phone if you're arrested? Can they access your emails stored in the cloud? These questions have gone all the way to the Supreme Court, and the trend has been toward protecting digital privacy, recognizing that your phone isn't just a device, it's like a digital extension of your brain. One major case, Carpenter v. United States, 2018, said police do need a warrant to access your historical cell phone location data. And in Riley v. California, 2014. The court ruled that police can't search your phone after an arrest without a warrant. Why it matters today. In an age of smart devices, surveillance, and big data, the Fourth Amendment is more relevant than ever. It reminds us that privacy is not a luxury, it's a right. Whether you're dealing with law enforcement or just thinking about how much information companies or governments collect about you, the Fourth Amendment serves as a powerful shield. But it's a shield that only works if we understand it and demand its protections. James Otis, a lawyer during the American Revolution, once said, "One of the most essential branches of English liberty is the freedom of one's house." That spirit lives on in the Fourth Amendment. So the next time someone says, "If you have nothing to hide, you have nothing to worry about," just remember, it's not about hiding something, it's about keeping power in check. Thanks for tuning in. Stay informed, stay empowered, and as always, stay free, stay informed.